Start. Para. Present petition assails order dated 18/3/2024 passed by the trial court. By virtue of the impugned order, the trial court has held that the suit filed by the writ petitioner plaintiff is not maintainable as the principal relief prayed for by the writ petitioner plaintiff cannot be granted by the trial court. The impugned order is at page number 18 of the writ petition. It is seen that writ petitioner plaintiff has filed suit for various reliefs, administration, declaration, and injunction. Simultaneously, writ petitioner plaintiff has filed a petition in this court for seeking letters of administration in respect of the suit properties of the deceased. To appreciate the suit filed by writ petitioner plaintiff, it is necessary to consider the reliefs prayed for by the writ petitioner in the suit filed before the trial court. There are total 12 prayers prayed for by the plaintiffs. For convenience, only the final prayer are taken into consideration. The first 5 prayers are final prayers. The gist of these 5 prayers is as under. Para. From the above, it is seen that writ petitioner plaintiff has prayed for appointment of administrator, disclosure of all movable and immovable properties of the deceased, disclosure relief against defendant number 1, declaratory relief against defendant number 1, and injunctive relief against defendant number 1. There is a further injunctive relief against defendant numbers 4 to 8 from transferring any benefit to defendant number 1. Plaintiff claims to be the sole beneficiary under the last will and testament of the deceased, who died on 26/9/2023. Deceased was the elder sister of the writ petitioner plaintiff. Deceased left her last will and testament dated 4/12/2010, bequeathing all her properties to writ petitioner plaintiff as the sole beneficiary. Writ petitioner plaintiff has filed a petition for grant of letters of administration with will annexed in respect of the estate of the deceased bearing lodging number TPL/1582/2024 in this court on 12/2/2023. The defendant is the daughter of the predeceased husband of the deceased. Para. In the above background, the impugned order passed by the trial court holds that since the suit is filed for administration, declaration, and injunction, the jurisdiction to issue letters of administration is within the original jurisdiction of the High Court only. It further holds that since plaintiff has allegedly applied for grant of letters of administration in the High Court, filing of suit seeking relief for administration of the properties of the deceased and other consequential reliefs in the City Civil Court is not maintainable as the principal relief claimed by plaintiff cannot be granted by the trial court. Para. Mr. Joshi, learned advocate appearing for the writ petitioner plaintiff, would argue that though the testamentary petition for grant of letters of administration is filed in the High Court, plaintiff desires to seek substantive reliefs for administration of the properties belonging to the deceased in the interregnum and until the decision in the testamentary petition is made. He would submit that in the petition seeking grant of letters of administration, plaintiff cannot apply for reliefs for seeking administration of the properties of the deceased and consequential or interlocutory reliefs.